is involved here. So first, the movie, the 2010 movie, Inception, by Christopher Nolan, is just chock full of fantastic quotes about memory science, the nature of reality, and layers upon layers of implanted or distorted senses of reality. So, and it's very deep. It usually takes 2 or 3 plays of that movie before you really understand everything, and you pick up new things each time. Memory science is very complex. Our brains are very complex. Our impressions and understandings and what we think are memories in the layperson's sense of the word are actually not. So when you take the fundamental misunderstanding of what memory is and how memory works, and the science of the extent of children's susceptibility, and then you morph that over into the family law world and the criminal law world, you get some real problems. And how the system is dealing with this lack of understanding, at least so far today, is unsatisfactory. So first, what is probably the best quote on memory from the movie Inception? And in particular, given that this organization, False Allegations Canada, it's all about distortions and implanted memories. So here's the quote. What is the most resilient parasite? Virus, bacteria, fungus? And the answer is none of them. The most infectious thing is an idea. An idea is like a virus, resilient, highly contagious. The smallest seed of an idea can grow. It can grow to define us or destroy us. Once an idea has taken hold in the brain, it's almost impossible to eradicate. So there's just some tremendous insight into memory science from the movie Inception. So when you play it again, there's lots of tremendous quotes. And if you search some of the quote sites about the movie Inception, you'll see it's really a fantastic script. So with that in mind, how does this actually play out in family law, in civil law, in criminal law? Well, those of us who practice family law always benefit from the teachings and writings of Bill Eddy. Bill is a lawyer and a social worker. He's a licensed clinical social worker, has published multiple books, articles, and speaks at many of the key conferences. So Chris has made me co-host, so I should be able to share screen and see if I can pick the sub screen to there. There it is. Okay, share. Okay, so everybody's pictures are going to be minimized. You should all now be seeing this very short article from Bill Eddy, very readable, that appeared in Psychology Today. And so Bill is writing here, and here's his key points. I'll leave it up on the screen. He's recently published a really tremendous piece in response to some of this unfortunate legislation that's being pushed in the United States that you may have read about. One of the latest states to have this push, I believe, is Arizona. They're suggesting that when a child turns 14, that's it. Forget about the family law case. Just whatever the child wants is what we do. And there's no best interest tests. You're not allowed to challenge the veracity of the assertions or preferences or any manipulation. It ends. So basically, we bring the corridors expired 18 down to 14, and Bill just published a beautiful piece resisting that. But you can see here that Bill identifies that children's brains go through various stages, and there's a tremendous amount of growth and change up to about the age of 3, as some of the very basic primitive structures necessary to be alive kind of settle down. But then there's this other explosive growth that starts in and around, all different in one sense. What I've read is age 10 for girls, age 11 for boys, and continues right through the teenage years, where the brain develops it again, certain functions that are less necessary because the child is older get pruned, and more sophisticated structures get built, and the changes, the physical changes, when they look at it on brain scans, start back to front. The last piece to develop is the prefrontal cortex, right in front here, and it's the emotional and cognitive regulator, and it synthesizes all the other pieces. And the prefrontal cortex doesn't fully mature till around age 24, 25. But yet, our family law puts increasing weight on the voices of children as they hit 14, 15, 16, and yet those are probably some of the worst years to just go with the voice of the child, put a lot of emphasis on it because of what we understand of the teen brain. We have 110 years of driving statistics that show, and anybody who has a child, a young adult, knows that you pay a tremendous amount of insurance for them, but then when they hit 25, the insurance rates fall right off the table, and they're a fraction. And it's a function. There's your test. Very large sample, of course. Around the world, insurance rates for younger drivers drop at age 25. Some car rental companies won't rent to anyone under 25 for the same reason. Okay? So we know there's all of this development going on. So how does that impact the credibility and reliability of what children are saying? For those of you who are old enough, you may know of the false memory controversies of the 70s, 80s, and 90s, with some very high-level, really unfortunate litigation where people were falsely accused, very much like, and in hysterical fashion, because we're dealing with children, and if the allegations were true, it's awful. But it created kind of a mass hysteria, like the Salem witch trials of the 1600s, whenever that was. Thankfully, some leading researchers jumped in and pushed back, saying it's based on a fundamental misunderstanding of how memory works. So let me put this article up on the screen. And I'll work with Chris to get all of this stuff to everybody so that you don't have to worry too much about writing everything down. So what should now be appearing on your screen any second, there it is. This was an article about a year and a half ago in the New York Times, which was a reminder of everything that you see there. There's the reference to moral panic. Everything that had been learned in the 80s and 90s in response to what developed in the 70s of a whole therapeutic insistence that what's troubling a lot of people is buried trauma of some sort. And the therapist would just dig and dig and dig and dig and suggest to their patient that there's something there and you're holding back, and I can't help you if you're holding back. And you can only imagine the impact on a younger person faced with that. They're going to invent the memory to get out of this pressure, or they're going to start to, why is he so sure that there's some buried trauma? Maybe there is some buried trauma. And the mere act of thinking about it can actually create that little seed of a memory. And then through session after session after session, it grows. It's very much like the movie Inception and that quote that I gave you. So this is a tremendous article. I'll show you later just a snippet of the massive library that I have here, because it's so important to my practice, of books on how memory works and distorted memories and false allegations of abuse of various sorts, the suggestibility of children, the proper interviewing of children. This is a very rich topical area. And so, this is just a wonderful article. They even give you a little bit about the genesis of where this whole concept of, I've highlighted it, repressed memories comes from, all of which has been debunked. So if you really learn about memory science, I experienced a traumatic memory, I've buried it so deep that I can't articulate anything about it, and I'm interviewed over the years, and then all of a sudden it comes out, runs against our current understanding of how the brain works, how memories work. So you'll get this article. It's truly fantastic. Now, we still have people who are anchored on some of the mistaken understandings, including people currently practicing in the helping professions, who are still anchored because of when they were trained on repressed memories. And what do you mean there's no such thing as a fully repressed memory? And they struggle with that. So I won't put it up on the screen, but a colleague of mine sent me a response, letters to the editor, so to speak. I don't know whether New York Times picked it up or not, but a response to that article sent in by two practicing clinicians, challenging some of the assertions there, saying we're trauma experts and we know that trauma gets buried. And so the helping professions still have a lot of work to do to get rid of all of that older teachings. And of course, when somebody publishes a book called Repressed Memories, it's still there. You can still find it in libraries. You have to study the area to know that that is now debunked old thinking. And I'm going to show you what the current thinking is definitively in a second. The New York Times article that I showed you is amplified by a lot of peer review science. And here's one that I will put up and share. So I'll just share screen for a sec. And again, I'll be sending all of this to everybody. Okay, so you'll now see this. So here's an actual journal called Memory. So in addition to all the textbooks and everything, if you really are a university professor or researcher or practicing clinician, well, then you might be interested in this online journal. So you can see the reference here to Tand Online, that's Taylor and Francis, and you can see up here Routledge, which is a really good senior publisher that is now part of Taylor and Francis. And you can see here the fallibility of memory in judicial processes. And this article in a peer-reviewed science form goes through a lot of what the New York Times article was telling us. This one has a little bit extra to it because it identifies 3 of the most notorious cases where distorted memories almost created a major injustice. So well worth reading this particular article. So what do we actually know definitively, and how do we know that the source is an authoritative, definitive source? Well, it would be great if the psychological community got together and published official professional standards that then got applied worldwide, saying, as a science of memory, science is always evolving, right? The whole nature of science is to prove and disprove and find another way to look at it, which calls the previous science into question. Science is meant to always evolve, but at any given time, there's generally a broad-based consensus in the scientific community. So it would certainly be great, given the impact that memory science has in family law and criminal law, if there was a worldwide scientific consensus on this. Just from my own research, I think there could be, but there isn't. It's quite scattered, and some effort definitely needs to take place to pull it all together. But I'll show you the best, something that comes closest to a consensus statement that, for whatever reason, is not well known. I was speaking at a conference in the United States, and there was a professor there of memory science and related things, and I mentioned what I'm about to put up on the screen to you, and it wasn't familiar. So just shows you that it's such an important topic. There needs to be more international dialogue and pulling everything together. You know, there's, I guess, a controversial aspect to it in terms of how much weight are you going to put on historical repressed memory due to trauma thinking, which for the most part has been debunked. But anyway, that's it would be nice if we got that, but here's the definitive document. And again, I'll share screen, and you're all going to get a copy of this. Okay, so how's this for a definitive document? The British Psychological Society, the research board of the British Psychological Society, guidelines on memory and the law, recommendations from the scientific study of human memory. So what this study is all about, it's some 52 pages long, but it has an executive summary that I'm going to take you to in a sec, is this is a consensus statement, albeit only of the British Psychological Society, that members of their profession in England are well placed, if called upon to testify or to write a report, on the basis of what's in this document. People can take comfort that the science is advanced enough that You meet all standards of your profession if you ascribe to what we're going to see in the executive summary. But of course, this is not a worldwide consensus statement, but more people should know about this document. So here's the executive summary, key points. So what they have in the list of key points here are the consensus statements that they consider settled science. And let's go through each one, and I'll try and amplify a little bit. Memories are records of people's experiences of events and are not a record of the events themselves. So think about it. You can have two people in the room and it's some event or incident or argument or controversy, and they can both remember it differently. Honestly, not taking a position later on to assist in a further argument, but rather they're actually, what they retain from the interaction is different than the other person. So think of the implications of this. If you have one person who said, look, I was there and this is what happened, and you have another witness who says, I don't know why they're saying that maybe they're getting senile, but I was there and that's not what happened. This is what happened. They could each be trying to tell the truth as best as they're able to recall it. So now think about the interaction between a parent and a child. Parents generally in the power position, unless in a parental alienation case where everything gets turned upside down. And they're going to have some dialogue and the child's upset and thinking of it in a uniquely child-centric way. You can see how they may each parent more mature, able to maybe depersonalize the experience a little more, and parent and child remember the interaction differently. Entirely possible. So if someone is trying to find truth, as I've been told by various children's aid studies along the way, it is our policy to believe the children. Well, you're not going to be of much help then. Has a child ever lied to you? Has a child ever been mistaken? Has a child ever been manipulated, as we'll see in a sec? So right away, you're getting into trouble. Okay, point 2. Memory is not only of experienced events, but it is also of the knowledge, in other words, background context. And that's because there's a purpose to the encoding that our minds do. Our brains are prediction engines. They were built the result of millions of years of evolution from other forms of life that eventually in our branch became human beings. They're there to predict how to find food, how to avoid being eaten, avoid dangerous situations, and how to procreate. That's the purpose of the brain at its most base level. If we can take prior experience and use it to predict, then we're in another circumstance and our brain searches for prior meaning in order to predict what this new situation might be. So that's a lot different than just simple recall. There's a context, there's a feeling. The last time I was in a situation like this, how did I feel? What ultimately happened? what might happen, meaning our memories get colored. There's a lot more than the actual original event that gets encoded. And that flows into point 3. Memory is I think that there's some better language here. Encoding memory is a constructive process. Remembering is a reconstructive process. So the example I give people is, if you are a digital iTunes collector, I'm dating myself, I still am, I don't just have streaming, I like to own my digital media. I also have a huge DVD and Blu-ray collection, you know, that places me in a certain era. So when you try and remember, you don't have this perfectly indelible digital music file that gets brought into the processor, replayed bit by bit, perfection, exactly as it was recorded in the studio, and then released because iTunes is then going to play another song. You can do that 1,000 times, and it'll be bit for bit perfection. It was encoded exactly as intended, and every time it's recalled and resaved, unchanged. Memory, the encoding of memory in the first place and the recall of memory in the second place, is literally the exact opposite of playing an iTunes digital file over and over again. Not everything is encoded in the first place. Only those bits and pieces and feelings and impressions that might be relevant in a predictive sense in future. There's a lot of context that's not encoded in the first place, but that might, in hindsight, prove ultimately to be needed or relevant, but it's not even there to draw from. And then life goes on, and you have all these other experiences and people telling you things like bad things about your mom. And then all of a sudden there's a situation you're placed in, and your mind is a prediction engine. Oh, I'm going to be in the same place as my mom. I'm anticipating this will be really scary for me. And that has as much to do as the evolution of the child's aggregate experience and knowledge base as it does the last set of interactions the child had with his or her mother. Because we're going to construct memory as we recall in an effort to predict how this forthcoming interaction might be experienced. So memory is a reconstructive process, and therefore everything about it could be completely tainted. Psychologists have 2 phrases that are used to describe this process. We create internal working models of people, of places, of events. It's the model that we remember, and the model is an amalgam of actual prior experience, things we've been told, things we've read, things we've imagined, all mixed together. Okay, point 4. I've kind of made that. Memory for experienced events are always incomplete. Point 5. Memories typically contain only a few highly specific details. I've also made that point because we don't encode everything. Our mind kind of, to save space, literally, only saves the essentials that might be relevant to future predictability. 6, Recall of a single or several highly specific details does not guarantee that a memory is accurate or even that it actually occurred. So just because, well, yeah, no, the child was with his mother at Canada's Wonderland, and then the child says, oh, you know, she was mean, she got lost, and none of which happened. But there's little bits and pieces. Could I just ask James to go on mute? Because I think we're getting feedback there. So there are bits and pieces that are anchored in reality, but a lot that is not anchored in reality. That's what point 6 is telling us. Point 7, the content of memories arises from an individual's comprehension of an experience, both conscious and unconscious. So it's not a digital picture. This kind of ties into the first point that two people can actually experience an event in different ways with different meaning, because they're coming at it from different perspectives and different feelings that they're harboring at the moment and different goals. Now, point 8 is about confabulations. People can remember events that they have not in reality experienced, like just completely fictional. And of all the things, remember, this is on the list of accepted science. You can testify in court as an expert on these points. But this is the one that you can kind of struggle with. Like, I can see how impressions can be tainted, and I can accept that memory is a reconstructive process, but a complete, you weren't even in the country, but you remembered being in this particular city and being abandoned by a parent, like a complete fictional implant, like the movie Inception. That one is a little bit harder until you do a lot of research and see how it's done, because they've actually done science experiments where over the course of 1 hour, they've convinced the child of something that the child was in absolute denial of at the beginning of the hour. By the end of the hour, the child absolutely was 100% certain that it had happened. So I've seen some of those videos, some of that science, and it's amazing to see. Bill Eddy, and Chris, if you can remind me about this, Bill Eddy has a somewhat tongue-in-cheek document called Dental Alienation, that it's not in this folder, and rather than go look for it, I'll include it. And he just shows in a back and forth discourse with the child went from being completely neutral, oh, I got to get my teeth cleaned, to being completely frantic, not going to the dentist, just in what might be a 4-minute dialogue back and forth. The parent moved them in bits and pieces just over the course of that dialogue. It's really, as they say, a picture tells 1,000 words. So I'm going to include that. But again, as I said, of all the settled aspects of memory science, that's perhaps the hardest one to really wrap your head around. Then I saw it myself live in real time in a case earlier, well, 2024 already, last year. So I'm going to, because of the importance of accepting that confabulations, an utter complete fiction, can happen. Let me take a couple of minutes to describe this one, because it wound up being in my trial submissions. It was incredible. So it was a trial about false allegations of sexual abuse. And there had been a whole series of false allegations, and the local Children's Aid Society on board, not verified, not verified, not verified. I'm just admitting somebody, Chris, it popped up on my screen. And then the parent who was making the false allegations complained, and so the supervisor and the caseworker had to cycle off the file, and a new supervisor, a new caseworker attended a meeting that the offending parent and 5 of their acolytes, service providers, domestic violence advocates for them, their doctor, their therapist, their this, a whole group of them came in to make a big show that the society had gotten it wrong the whole time. And you could see that the incoming caseworker and supervisor said, okay, well, we're going to have to take all of this and we'll study it. We'll study the file. We'll get back to you. But it just so happened that maybe about a week or so later, the children were to spend 2 weeks in the care of the other parent, the innocent parent. And as a matter of fact, the very day of the conference, the children were in the care of that parent. And these were children who were old enough to have a mouth on them, like not a little kid who you could just kind of threaten them into silence or anything like that. So you would expect that the incoming team with a file like this would want to interview the outgoing team, not just poke their way through a rather thick file, but like, on what basis did all the prior workers say there's no meat here, this is all false? But they never did. They just read the file, said, where there's smoke, there must be fire. There's so many allegations, but it was all duplicative and triplicative because the offending parent would lob one in and then tell their doctor, and then their doctor would have to report it, tell their therapist would have to report it. So it looked a lot bigger than it actually even was. But there was tons of evidence of this being false that was ignored by the incoming Children's Aid Society team. They ran to the cops because they did not want the innocent parent to have the children for this 2-week vacation. It was a complete abomination of an investigation. I wouldn't even dignify it with the word investigation. It was a witch hunt. It was a moral panic, Salem witch hunt sort of situation. And the innocent parent was charged with significant things, actually narrower than what the society was advocating for. Thankfully, the charges were dropped later, but too late to save the relationship with 2 of the 3 children. So we get to trial, and the 2 incoming workers, the worker and the supervisor, they've already testified, and I've gone at them real hard. Why didn't you have a transfer meeting with the previous team? You can't just read this file and say, and then misinterpret it and say, there's all these allegations, something must be true. It's not like the person left the agency, they're still there. And they were bobbing and weaving, and eventually I got the admission that they were in a blind panic because they wanted to kill the innocent parents' 2-week vacation with the children. Okay, just reprehensible. So then I get the outgoing caseworker. And it's a virtual trial, so it's happening on the screen. And so I'm interviewing him and all of his prior conclusions. And then say, we've what's the policy if you're moved off a file? And he said, well, I do a transfer meeting and I call it, the outgoing person calls it and whatever, etc. Did that happen here? And here's where it gets really interesting. So he says, no, I don't recall it did, actually. I don't recall that it did. And so then I'm probing but how can that be? Like, where's the internal controls in the society? And could you think of a reason? Were you away on vacation? Like, why this didn't happen? And then I fill him in that, this led to the complete 180, abandoning everything you said. So can you explain it? And then all of a sudden, his recall changes. He says, I'm thinking about it now, and maybe there's a possibility we did do a transfer meeting, because I'm pretty good about that. Like, I won't just walk off a file. Like, and I remember transfer meetings with employee A and employee B. It's a kind of a smaller society, so there've been other transfer meetings. And so anyway, so my turn's up, and then other lawyers are examining that witness, and then I get reply. And a lot of people are dancing around the same topic. And so then I'm dealing with him in reply. And he said, no, you know what? I'm remembering it now. We did have a transfer meeting. And I said, but how could that be? You weren't here. We had those other two witnesses, and they were very definite that there was no transfer meeting. And they were quite defensive about why they didn't ask for a transfer meeting. So are you sure there's a transfer meeting? Because we had your two colleagues here already saying there wasn't one. And at this point, he had completed the 180 degrees, and he said, no, I can definitively state there was a transfer meeting. I remember talking to them about this file. And of course, you go to the records, that very strict standards of record keeping for societies, and there was no transfer meeting. And so there you are. That's a confabulation. It took less than an hour, and with an adult, not a child, and on top of it all, nobody was trying to convince him that a transfer meeting had taken place. I was just asking questions about it because it sounded so anomalous, and policies and stuff. His mind created, and he was credible. He had no skin in the game. He's not the one who made the errors, but his mind created from a whole bunch of other memories, and the topic being parsed, his mind created this memory, and that was a confabulation. So yes, no, I didn't just see this in films of science. It happened live and personal on the very computer screen I'm looking at last year in a trial. So there's a child under pressure by a parent to adopt an attitude or to adopt an allegation doesn't stand a chance. If what I saw happened, and I saw it happen myself. Truly fascinating. Okay. Now, memories for traumatic experiences, item 9. Childhood events, interview and identification practices, memory in younger children, older adults, and other vulnerable groups all have special features. So the science would have something very particular to say about traumatic experiences, childhood events, etc. And then number 10 just goes to who's allowed to testify about all of this, not just your run-of-the-mill psychologist or social worker. has to be a university professor or a practicing clinician in this area. Okay, now, in addition to what the British Psychological Association has done for us, which a very, very welcome document in trying to create some sort of a consensus of what we know and what we don't know in the area of memory science. It's not definitive. There are other things we know. For example, memories of particular events degrade over time. You don't acquire details. You lose details over time. So if a child is interviewed at age 6 about something that happened at age 4, because remember that second to last point said, memory science for younger children, there's some special aspects to it. We do not remember details of our lives younger than 3 years old. That's that first fundamental change in the brain. So if some child says, yeah, I think I was about 2.5, and somebody was touching me wrongly, our science tells us that's not really reliable. But if you have a child who, when asked about an event at age 6, says, here's what I can remember, this, and this. And then 2 years later at age 8, they're asked about the event. And suddenly they know for sure that the other parent was wearing blue and where they were, and not the way the mind works. We lose details over time. And over time, the risk of the supplementation of the core kernels of the memory supplemented by other things that didn't happen rises. That's fundamental science as well. Okay, so let's say you are unfortunately heading into court, be it a civil court for civil damages for something, or family court or criminal court. Is the court supposed to know this? Do you need to hire an expert to testify about this every single time? That could be expensive, ponderous. Experts are not even readily available in many jurisdictions. So how do you get this knowledge into court? Are judges supposed to know this? Is this part of our rules of evidence that, of course, judges are supposed to be expert in? Well, let's go to our next document and we'll find out the answer to that. So it's just loading. Okay, here we go. And again, Mary just joined us. Hi, Mary. All of these documents will be distributed, so nobody needs to be writing feverishly here. Okay. Okay. So this is part of legal submissions on how courts deal with, and if you just look at the table of contents, because the idea of today is not to turn all of you into legal experts. The first section is all about the court as the gatekeeper for any opinion evidence. Opinion evidence is presumptively inadmissible, particularly where it impinges on the ultimate conclusion of the trier of fact and the related remedies, but it can be admitted if it would supplement the judge's knowledge. It's on a technical issue. It's based on settled science, not some novel science. And you comply with, there's a whole host of evidence law rules for the admissibility of expert evidence that, again, goes beyond today. So there's a whole body threshold analysis before you can even get it in the first place. But look at the third line, judicial notice and the nature of human memory. If it is the case that understanding that memories could be false, memories could be corrupted, memories could be influenced, memories degrade over time, is expected to be part of the judicial repertoire, then arguably the expert you're trying to have testify about all of this can't testify, because it's just part of what judges are expected to know, and it won't pass the series of hurdles involved in getting the evidence in. What this memo in its totality, and I don't have time to go through it. I think the index even continues, or no? Okay. So there are cases all over the place on, is a memory science expert's advice to the court even admissible in the first place? And some of them relating to the same expert. There's York University has one particularly well-known person and who's now trained and up-and-comer. And you can find cases where the court, oh yeah, come on down, I can really use this. And other cases saying, I know all that. I don't need to be told all of that. I have to use that sort of knowledge in all of my cases when I weigh witnesses' evidence. So there's not a lot of predictability, but the more complex the situation, the more likely it is for you to be able to get it in. Okay, so there is a large body of law on when, if, how, maybe not, you can even get an expert to advise the court about this. So that'll be part of the package of materials. What else do I have for you? Okay. If anybody's really interested in a deep dive, I'm not going to send this out. I have kind of a curated index to my library on memory science, children's suggestibility, children's interviews, etc. And I keep buying more. It's terrible habit. I'm just fascinated by the area though. And I'll just show you one that was, I guess, a recent purchase. Was there was a review about it. So just give me one sec. Okay. Yeah, so there was a review about this book in the Wall Street Journal. Just one of, again, great book, but one of many, many great books. But just to give you an example of what's out there. Okay, so here's the book review from the Wall Street Journal of The Experience Machine. So you see their little caption here. Our sensory organs provide the inputs, but memory and other forces shape what we ultimately perceive. So perception, what we take from experience, you can't just rely on your memory. And so here's your book, The Experience Machine, How Our Minds Predict and Shape Reality. But if you want probably the most accessible book in the sense that it's based on solid science, but it's written for more of a highbrow mass market. There's a book by Dr. Elizabeth Shaw called Memory Illusion. Also came out about 5-6 years ago. And that's where I would start. If you really want to learn about this area, start with Dr. Shaw's book. Again, as I said, it's based on solid science, but it's not designed as a professional book, if you will, as a reference book, but really a great entree to this area. And this one is pretty good too. I haven't read it fully. I've just flipped through it. Okay, so I'm gonna stop there, and hopefully this has been, you know, an eye-opener about really a very important area that is not very well understood at all. And for you or anybody else ever facing a false allegation, just give me a call and I'll see if I can point you in the right direction. Okay, so there we are, Chris, and I can take a couple of questions.
That's great. Thank you so much, Brian. If anybody has a question, you can either post it in the chat and we can read it, or if you're comfortable, just raise your hand and we can get to your questions. William?
Hey, everybody. William. Thank you, Brian. That was really, really illuminating. Great presentation. A lot to take in. I did have a direct question. I'm 5 years into a family law situation, and so we've gone through all the briefings and all the settlement conferences and all of these things. And the other party has put in affidavits all the way along the way. And what was in the original affidavits has gotten more and more detailed. New things are coming up all the time, even 5 years in, and some of them are to the point of absurdity, something that you're like, if that happened, you know, you would have remembered it 5 years ago, not now. And I know when it comes down to it, what this person's going to say is the more I had time to sit and think, the more these things came to me, and stuff that I've maybe buried have now come forward. And the one thing I can relate to is, you know, a friend of mine, and we used to go to like hundreds of concerts back 30 years ago. And there's times that I would forget that I even saw a band with him. And I would call him up and say, did we ever see so-and-so? And he would say, yeah, we did. And that would literally almost open a pathway to that memory. And then I would have certain flashes of that evening that I know are legitimate, and because I know I was there. But that would have been unavailable to me without the right cue. So I'm wondering how you navigate this type of stuff where people are adding to stories and creating new things and then finding ways to kind of defend it that people are going to maybe think are plausible. And I'll pass with that.
Okay, very well stated. And the simple answer is, in what you gave us, they've been given the cue. So some, you know, feed me the dirt on dad, and they've been given the topics. So at that point, whatever they're capable of remembering is going to come out. They've been cued. The mind is going to go back and try and recreate, because memory is a reconstructive process, or recall is rather, and they're going to try and recreate what they can. The very fact that it wasn't remembered in the first place is because nothing happened. Like, you enjoyed the concert, but it wasn't so central to your existence that your mind necessarily needed to encode that as a predictive tool. In case you ever found yourself in that concert hall again, you would feel good about that concert hall. It was a great experience in the moment, and at some point it got pruned. But if you experience abuse, you don't want to ruminate on it. It's very unpleasant. But what the science is telling us is, you're not going to, particularly when it's cued, right? Did your father beat you? Did your mother abandon you? Did your mother scream at you and embarrass you in front of all your friends? There's your cue. And so what I will do frequently is imagine, like, and because this is what I do. I build an 11 by 17 chart where down the left-hand column is all the different allegations as they have ever appeared throughout the case, to the office of the children's lawyer, to a therapist, in an affidavit, to a teacher, whatever the source, the allegation gets a horizontal row. The vertical columns is where do we find it? And if it is expressed differently over time, we'll note that, like that item, that topic, we'll note like column 4. It was in so-and-so's affidavit of this date, in this paragraph, but in a different form. And if there's room, we'll put in a little cheat sheet thing of in what way did it differ. And I'll tell you when that comes out. This is, I'm really happy that you prompted this, because this is a great tool, a visual, these charts. So in the case that I'm thinking of, there were certain allegations that appeared, and there was a lot of anchoring on this is why the kids don't want to see their father. And then it's like they disappeared. And then in the subsequent forums, that was no longer on the top 10 list. Not very likely. They just disappeared. And there were other allegations of events that predated column 1, whatever column 1 was, that didn't appear, but all of a sudden in column 6, there it is. That's also suspicious. Then there's the classic. Here's the scene. It's a 2-story condo, and the younger child is sleeping upstairs, and the older child is bouncing around full of energy and opens up the door to go upstairs to play, to look for the son who's sleeping, and she doesn't know that the son's sleeping, and the father like holds her back. No, you're going to wake up the son. And so, she kind of stumbles a little bit and maybe even fell at his feet, but like no injury, no nothing. This has happened a million times in a million families. There's no issue. Well, that appears in the other side's affidavits, OCL interviews, etc. First, as he tripped her down the stairs. Then it morphs to and remember, this scene takes place at the bottom of a flight of stairs, preventing her from going up. But it appears in affidavits as he tripped her down the stairs. Then when that isn't good enough, it morphs, he pushed her down the stairs. And when that isn't good enough, it morphs to he threw her down the stairs. Okay? So the visual of showing this, you guys should see each other here. This is striking a chord with everybody. But, they say truth is stranger than you can't make this shit up. There it was. So the visual of doing allegations in a chart like this is extremely possible. So let me just give you the 3 major categories again. You've got allegations that the other side is anchoring on, and then, well, they've invented other stuff, so I don't need that one anymore, and it disappears, but it was very, very important, and it doesn't appear in any subsequent affidavits. Then you got others that are the reverse, doesn't appear, should have appeared because of the dating of it, and then suddenly appears and it's a big issue. And then you have allegations that morph over time, okay? And that can really be easily displayed in chart form. Okay, so.
That's great. That was a great question, William. Great answer, Brian. Thank you so much. Sean, you're up.
Can I just ask Sorry, can I ask one tiny little clarification there, Brian? That was fantastic. But in Ontario law, are you, because settlement conferences are sometimes closed, are you able to go back and use all those affidavits, or are those now, because that seems to allow people to
Okay.
make up crazy stuff and have it thrown out, and I won't ask after that.
Right, okay. So nothing stated in a settlement conference or in a settlement conference brief can be used anywhere else except with permission of the court. If it's not settlement related, they're not compromising their position in any way, it's a trial false allegation, then you could probably get permission to use it. It wasn't advanced with the view to settlement, it was advanced with the view to you capitulating, okay? But at first blush, you don't have the initial ability to do it, but you can recreate it by writing a letter saying, recently, you don't say where, your client accused my client of X and there had never been, please confirm. You're asking them to make a statement about it outside the context of the settlement conference. And if they know that it's false, if they do respond that it's live, if they don't respond, you just keep writing. Hi, I'd really like an answer to that letter because I think you just made it up. Okay, don't pretend you didn't say it. We're not saying where you said it. And you just keep hammering away, hammering away, hammering away. Okay? All right.
That's excellent. Thank you so much. So Sean, you're up, and then Mary will get to your question right after Sean.
Good afternoon, Brian. Thank you very much. You almost described my situation about to having the children. On that, I have the CAs forcing my son to lie on the audio recording. What's the probability do I have to put the CAs under the liability about all the expenses I am incurring, criminal charges, criminal cost, family cost, because of them is happening?
Okay, so, well, the first thing you should do is escalate it internally and get them to officially state they accept it's untrue and that worker's being disciplined and whatever. So run it right up the chain, because you'll also be doing the public a service because that worker is liable to do that to another family and you don't want that.
So, Brian, can I just jump in and just clarify something? So Sean is facing criminal charges and that's recent. So I'm just wondering what should be dealt with first, the criminal side or the CAS side?
Well, obviously you're going to want the two counsel to confer, but if Sean's position, I mean, this is kind of a sidebar, right? It's supportive of Sean saying, I didn't do that. This is completely false. So never do anything without your counsel being in the know.
I'm sorry. It's not like I am saying I didn't do it. The CAS worker put my son on the call to confront me. And my son says, oh, this is not happened. And the CAS worker was forcing my son to say.
I got it. I understand. Same answer. Make sure your two counsel chat. And I think you escalate that within the society as high as you can to get the higher ups to censure that worker, to publish a retraction, and then your criminal lawyer will be able to use that. Okay? All right.
Sean, does that answer? Are you clear? Yeah, good stuff. Mary, you're up. Go ahead with your.
Will I be able to sue them for all the expenses?
Okay, so second question. Ontario law, unfortunately, is such that it's almost impossible to sue a society for negligence, but this sounds like it's crossed the line into defamation, malicious prosecution, etc., that you can sue them for. So again, speak to your lawyers.
All right, Mary, go ahead.
Hi, thank you. Hi, Brian. Good to see
Hi,
you
Mary.
again.
Good to see you.
My case has been 18 years long. I went to trial last year. My ex-husband brought the kids back. They were now adults, 34, 33, and 31. And one of them suffered a psychotic episode on Zoom trial because he had to lie to replace the lies from 18 years ago. So the lies became so severe that he suffered a psychotic episode. And the other two were crime suicide. I stopped the trial. I made an offer. And with that offer, they took it, but they came back at me saying that I could never take them to court again. I just wanted my kids. I told the judge I wanted the money that I got for unification therapy, but I haven't heard from them since. And it's been a year and 3 months now. So anyways, I started getting my file ready. I did a board, like you said, that you stated. It was incredible that you said that, because I have a board from 18 years ago to the middle to the end, and everything was so different. And the 31-year-old stated that the way she talked, oh, by the way, she did this. Oh, by the way, don't forget, this is, and all these things, by the way, 18 years later. But they denied the Office of the Children ever writing their affidavits 18 years ago, and they changed it 3 different times in the last 18 years. So they tried to put me back in prison on false allegations again, 18 years later. That's double jeopardy, is it not? And to me, that's defamation of character, because they got other people involved and they went through my medical files. They submitted all these paperwork to everybody and anybody. They got into my my OSAP. My children were using my SIN number to gain education, and I got charged for it. So for the last 18 years, I'm paying all these bills, but now I could prove it because I actually went to school last year to become to help people with their court papers, to read them and all this stuff. And I couldn't, because I owed OSAP thousands and thousands of dollars. So I got all that. I had to go to the government to get my name so I could change my OSAP number. But I don't want to change my OSAP number, because then that will delete my evidence for this. How long do I have to go to do a defamation of character? Can I, is there a time limit on this? I mean, the trial ended September 2022, but I got so sick, I couldn't do anything.
Okay,
My
so
heart, everything,
Mary, that's very complex, and this isn't the right forum. And I can't give file specific advice in a forum like this. So Ontario has a general limitation period of 2 years
2 years.
after the facts are known on which to found a claim. But what the scenario you've given is very complex. So this isn't the right forum for me.
Oh, it's not? Okay.
Okay.
So, but I do have 2 years?
Well, 2 years from when you first learned of the enough facts to found the basis of a claim. So that's our standard limitation period. There are other provisions that apply in other circumstances. So, but I can't say really any more in this context here. Okay.
Okay.
Thanks, Mary. All right, if there's no other questions, I'm going to stop the recording. Just on behalf of myself, Terry Lynn, False Allegations Canada, I'd just like to thank Brian for his time today. That was a great presentation. Thanks so much, Brian. Just for everybody, I've posted Brian's website in the chat for those of you that are interested in touching base with him outside this meeting. Thanks again for coming, everybody. Really enjoyed today's presentation.